Welcome to Legal Minds, and welcome to part 3 on the separation of powers. In this video presentation, I'll be covering some of the overlaps that are present between, for example, the judiciary and the legislature and the checks and balances that are in place. If you have not already seen part 1 and part 2 on the separation of powers, I recommend that you watch them. Part 1 is just a brief introduction, and part 2 goes into some of the overlaps between the executive and the legislature. Right, so the first thing I'm going to be discussing is the common law and how this is an overlap between the judiciary and the legislature. Well, the common law is essentially judge-made law. Common law is built on judges, so judges will come across a situation, come across some sort of real-life case which hasn't already been decided by legislation, and they will create a principle relating to scenarios analogous to the one at hand for future cases. So that's what the common law is. And so the common law is judge-made law. It's built on judges, and this is especially true with tort law, where the majority of tort law is made by judges. And yes, there are some things like occupiers liability, which is governed by statute, but generally tort law is governed by common law. And under tort law, there are fundamental principles that regulate our daily lives that have been created by the judiciary. For example, the case of Donahue and Stevenson created the neighbour principle. Lord Atkin created the neighbour principle, which means that we owe a duty of care to those who our actions could be reasonably foreseen to affect, whether directly or indirectly. So, for example, road users, they owe a duty of care to other road users because their actions can be reasonably foreseen to directly or indirectly affect them. And so if they fall below that standard of reasonable care, they can be liable and tort. And so principles that regulate the conduct of our daily lives, principles that relate to us on a day-to-day basis, have been created by the judiciary. Now, Parliament's the primary lawmaker. Should judges have the power to make this law? Shouldn't Parliament be doing this? Well, that's something some theorists would argue, just based on basic principles of separation of powers. Also, William Blackstone once held that judges should declare the law and not create it. So there's an overlap in that sense. The judiciary is creating law when we have the legislature, which is supposed to be our primary lawmaker, but we have areas of law that are really made by judges. Fundamental principles such as the neighbour principle that really affect us on a day-to-day basis are made by judges. Again, there are checks and balances on this power as well that judges have, one of them being parliamentary sovereignty. Now, Lord Stein, in the case of Jackson and others, I think it was, held that the supremacy of Parliament is the general principle of our Constitution. So, in our Constitution, the most fundamental and commonly recognised principle is parliamentary sovereignty. Now, the judges are not sovereign. Parliament is sovereign. That's what's believed to be, anyway. And you can say that Parliament is sovereign, but that's a whole other beast to tackle in another video as to whether or not they are actually sovereign. So I'll address this in a different issue, in a different video. But the two videos, my parliamentary sovereignty video, well, my series on parliamentary sovereignty and my series on separation of powers, will complement each other because they do, to some degree, intertwine. And so yeah, Lord Stein held the supremacy of Parliament is the general principle of our Constitution. So it's Parliament that's sovereign, not the judiciary. And as a result, the Parliament can do certain things to rectify this power that the judiciary has. For example, they can reverse judicial decisions, as was the case in the Burma oil case, in which the War Damages Act 1965 reversed a judicial decision to grant compensation to owners of an oil rig that was destroyed during the war. So legislation prevailed over the judicial decision, and this is one of the elements of parliamentary sovereignty, that statute is supreme. Statute is the highest form of law. It's superior to judge-made law. So if there's a conflict between statute and if there's a conflict between the common law, the statute will prevail. Now, in the Burma oil case, there wasn't a conflict between statute. There actually was no conflict between statute and common law, but the legislature didn't like the decision the judges made, so they enacted the War Damages Act and reversed that decision. Furthermore, even the role of the judiciary is essentially a check and a balance on their own power, because their role is to interpret the law and apply the law, is to interpret the law that Parliament passes, is to interpret legislation, statute, and apply that. Although they can make their own law, they are required to interpret the law of Parliament, which will generally govern many situations. And so in the case of Smith and Hughes, the legislation intended to clear the streets of prostitution, and the legislation held that it was illegal to solicit on the street. However, in the case that come before the court, the prostitutes were soliciting from a house. They were sitting in the window and calling clients into the house. And when I say clients, I'm not saying that prostitution is a profession. And the issue was, could the legislation be extended to this form of soliciting? And the judges held that yes, it could, because they looked at the intention of Parliament when passing the legislation, the purpose of the legislation, which was to clean the streets of prostitution, and so they extended it to cover this situation where the prostitutes were soliciting their clients, I guess you could call them clients, by calling them in from the window of a house. I guess I shouldn't really call them clients, because that kind of makes out that prostitution is a profession, and that's not what I'm saying at all. Furthermore, there are certain matters that judges will actually leave up to Parliament to decide on. If, for example, they don't feel competent enough to decide on this particular matter, then they'll leave it up to Parliament. There are two cases on the slide, the case of Bellinger and Bellinger and the case of Crown against Clegg. In the case of Bellinger and Bellinger, the issue was whether or not a man and a former man, so a man that had a sex change to become a woman, could legally marry. In interpreting the legislation, the courts held they couldn't legally marry, and they based that decision off of the wording of the interpretation, and essentially held that we're going to leave this matter up to Parliament. Yes, it may breach the convention, but we do not have the expertise to deal with this matter, so we're going to leave it to Parliament. And personally, I don't think the power the judges have is a problem, because try and envisage a world where the judges don't make law. Try and envisage, okay, for example, take the situation. Take a situation that isn't governed by statute. What would happen to the innocent party in the case? Well, they wouldn't be satisfied with the outcome, because maybe they couldn't claim for a remedy because there's no legislation governing the matter. So it's to a large degree important that judges do have the ability to make law. It also takes a weight off Parliament's back as well, because if Parliament had to legislate on everything, on every scenario, they'd have a serious hefty workload. They already do enough as it is. They debate on government bills, they go through the amendment process, they have to do all sorts, and so the ability for the judges to make law really does take away off Parliament's back. And they're not going to make law if it contradicts statute anyway, because the statute has to prevail. And even if they do create law that conflicts with statute, the statute would prevail. So it's not really an issue. The judges are also very adamant to make decisions that will affect issues of fundamental social importance, as can be seen in the case of Nicholson and Ministry of Justice. It's quite a sad case that involves Tony Nicholson, if any of you are aware of who he is, or was, sadly. And the judges have even gone as far as changing the wording of statute, specifically to make it convention compliant, so to make it in accordance with the Convention on Human Rights. So Parliament is supposed to have the role of not only making law, but the role of changing laws, especially laws created by them. Yet, in the past, judges have changed the wording of statute to make it convention compliant. Now, if we had a true separation of powers, the judges wouldn't have had this ability. Yet, in the case of Gaydon and Godin Mendoza, the judiciary changed the wording of the relevant statute to make it convention compliant. In this particular case, the issue was whether or not a provision that related to married couples could relate to same-sex couples. And the courts held that it could. They changed the wording, they extended it to meet, I guess you could say, to meet the needs of same-sex couples in relation to the rights of this particular statute. However, as a balance to this, the courts are not very likely to do this if the particular wording in question goes to the very heart, to the very purpose of the Act. And so this can be seen in the case of Bellinger and Bellinger, where the courts could have changed the wording of the Act to make it convention compliant, but they didn't, because the wording went to the very grain of the legislation, went to the very core, the very heart of the legislation. So they left it as it is, and essentially said that Parliament needs to change this if they want, but we as the judiciary cannot do so because it goes to the very core of the legislation, so it will be unwarranted for us to change it. That's essentially what they held. Not in those exact words, but something analogous to that. And so this acts as a balance in a way, because yes, although the judiciary did change the wording of the statute to make it convention compliant, in the case of Gaydon and Godin Mendoza, the particular wording they changed didn't go to the heart of the Act. If it had, then they may have left it up to Parliament. You also need to understand that if it wasn't for the Human Rights Act 1998, which was created by Parliament, and that's important, the Human Rights Act incorporated the Convention into our domestic law that's created by Parliament. And if it wasn't for that, judges wouldn't have this power. And so it's almost a self-imposed overlap that Parliament has created. And at any time they wish, they could repeal the statute, they could change it so that the judiciary does not have the ability to alter the wording of statute, because according to the doctrine of parliamentary sovereignty, Parliament can legislate on any subject matter. Politically, this may not be the case, but theoretically they can, and they could easily alter the statute so that judges do not have this power. And I think part of the reason the judges did change the wording in the case of Gaydon and Godin Mendoza is because the Human Rights Act 1998 specifically instructs judges to interpret the law in accordance with the convention. So I think they were also trying to interpret the law in accordance with the legislation, in accordance with the convention, sorry. So it may not necessarily be a problem at all. And like I said, Parliament can repeal the statute at any time they wish. And so that's quite a big balance to this. It's not really that much of an issue, at least from my perspective. And that's it for part 3 of the separation of powers. Thank you for listening. In the next video, I'll be covering some of the overlaps between the executive and the judiciary, the checks and balances in place, and I'm going to be going over judicial independence in a fair amount of detail.